Good afternoon, ladies and gentlemen. I'm going to talk about Chapter 12, which is the initiation of the legal process, bail, and the right to counsel. So what we're talking about today is essentially everything pre-trial. I guess in that flow chart that I spoke of earlier in the semester, of course, this is the part where you're actually going to court. You've been charged, you've been identified as a suspect. Now you're in court, charged, and or now you're not even in court. So now you've been arrested. How does the legal process begin once you're in the system? You've been arrested. So as an introduction, this chapter discusses the prosecutor's discretion to bring a criminal charge and the defendant's first appearance before a magistrate or judge. The text focuses on two aspects of first appearance. First, pretrial release and bail, and the condition of pretrial confinement. And second, the right to an appointed attorney or lawyer for indigents, which are poor people, and the right to effective legal representation. So, the prosecutorial discretion to charge. Prosecutors retain a broad discretion over whether to file a criminal charge or over which criminal charge to file. There is a presumption of regularity, meaning that we automatically presume that they're being fair. So, of course, that presumption is rebuttable, but for you to rebut that presumption and to show that they're not being fair, that they're being racist or biased, you have to jump a high hurdle. But there is presumption of fairness, or we call it presumption of regularity. Courts presume that in the absence of clear evidence to the contrary, prosecutors honestly, fairly, and responsibly exercise their authority. Prosecutors may not engage in selective prosecution or vindictive prosecution. So what that means is they can't pick and they can't choose based upon some type of bias, whether it be racial, gender, any type of bias, sexual bias, or sexual orientation bias, or any bias of any kind. They can't prosecute based on a bias. So they can't say, well, I'm only prosecuting black people, or I'm only prosecuting straight people, and I'm going to prosecute gay people more. So they can't do anything like that. So they can't selectively prosecute, and they can't be vindictive in their prosecution. So they can't use the court as a retaliatory tool against people they don't like. That is, of course, that would be prosecutorial misconduct in that situation. Okay, probable cause to detain a suspect. In Gerstein v. Pugh, which we call Stein or Gerstein, some people say it, the case, the U.S. Supreme Court held that the Constitution requires a judicial determination of probable cause as a condition of a suspect's extended restraint of liberty. So that means there has to be a judicial determination. So when a person is arrested, the first thing that happens is they have to be taken in front of a judge or a magistrate. So that person can determine whether or not it's probable cause for the arrest itself. This non-adversarial probable cause hearing must be held promptly following an arrest. So when a person's arrested, they're arrested and they're taken into custody, and they're taken directly to a magistrate or judge. So that's Gerstein. So you're going to hear Gerstein here and a Gerstein here later on. In County of Riverside v. McLaughlin, the Supreme Court defined promptly and held that for a 48-hour period of delay is presumptively reasonable period of time within which to hold a hearing. So that means out of that case, they can hold you for a couple of days before they have to bring you before a court for probable cause to be determined. First appearance. The first appearance is triggered by the prosecutor's filing of a complaint. So once they file a complaint, then of course you have to have a first appearance. At the first appearance, a suspect is informed of the criminal charges and of his or her rights. The conditions for pretrial release are established, and a lawyer is appointed for indigent defense. What that means is that first appearance. Now in Guilford County, for instance, a person is arrested if they're held in custody. So if that Gerstein here, and let's say the magistrate puts a bond, or what we call a bond. We're going to talk about that in a minute. So you'll hear me say bond instead of bail. So when I say bond, I'm really talking about bail. So bail is nothing more than the condition of your release. So what that means is what it essentially is almost collateral for your return to court. So in other words, they depending on the seriousness of the case, and the person's prior criminal record, though things like that go into whether or not they're going to have high bond or low bond or bail. Of course, what happens, that person pays the bail, and we're going to talk about this in further length later on. But if they can't pay the bail, they can't afford it. Of course, they stay in jail after the Gerstein hearing. Now, within a certain amount of time, in Guilford County, usually the next day or the day after, they have to have a first appearance. The first appearance is all about determining how this person is going to be represented. In front of a judge, they're formally notified of what the charge is. A lot of times, what type of time they're facing, like the worst they could get, not as an individual, but the worst possible sentence a person charged with this crime, no matter what the record could get. At the first appearance, the suspect is informed of the criminal charges and of his or her rights. Of course, the main right is the right to remain silent. So judges usually don't like to hear what you got to say other than who you are, their information, but definitely they're not trying to hear about the facts of the case. So they usually tell you to be quiet and wait till your lawyer comes to see you if you get one. Then they also talk about the conditions of pretrial release. So at that Gerstein hearing, of course, the magistrate sets an initial bail or bond. At the first appearance, that judge has the authority, depending on what type of case it is, to change the bond. So at this point, they can change the bond. Now, it's not a bond motion at this point. I'll tell you what a bond motion is in a minute. But it's not a bond motion, and that means there's a motion out there that's been made outside of court and filed to reduce or change the bond. So it's not a bond motion, but a judge can look at the case without there being a bond motion and decide to set some type of bond or change the bond that's been set by the magistrate. And that's what I mean when we say conditions of pretrial release. So in other words, what are you going to be let go and sent out on your own recognizance, meaning sign yourself out? Are they going to put some collateral, which is a bond or a bail on it or whatever? Or they're going to say no bail or bond. In other words, there's no condition in which you can pay or get a bail bond to get yourself out of jail. And also, lastly, but not least, a lawyer is appointed for indigent people. So they want to figure out how you're going to be represented. Are you going to hire your own attorney? You're going to represent yourself, which you have a right to do. Not a smart thing to do, but you have a right to do it. Or are you going to ask for court-appointed counsel and that's for indigent defendants. So when we say indigent, what that means is poor or cannot afford a lawyer. So in the legal setting, we don't use the word poor, we say indigent. Now, pretrial release. The Eighth Amendment to the U.S. Constitution provides that excessive bail shall not be required. The bail provision has not been incorporated into the due process clause of the 14th Amendment. Most state constitutions, however, create a right to bail in all but capital cases. The bail clause has never been thought to accord a right to bail in all cases, but merely provides that bail should not be excessive in those cases where it is appropriate to grant bail. So it's always about proportionality. Bail is not compulsory, meaning it's not mandatory, where the punishment may be death. So they don't have to give you a set of bail at all if the punishment is death. So if you got capital murder, they don't have to set a bail. Bail is excessive where the figure is more than is required to guarantee that a suspect will appear for trial. In 1987, the United States v. Salerno case, the United States Supreme Court affirmed the constitutionality of preventive detention. In other words, detention to prevent some type of action. So if they feel like you're a danger to society, of course, in that situation, they can keep you detained. Bail, of course, usually in most jurisdictions, they have bail or bond guidelines, meaning to make it fair, they always set local guidelines. And that's the court system uses guidelines in what we call structured sheets and things that essentially give the court and the judges guidance as to what to do That way, they can kind of X out the possibility of there being any type of bias involved. So a lot of times, if I have a person that wants a bond motion, the first thing I do is I look at I look at what they're charged with, and I look at the local guidelines or the bail or bond guidelines. Like what is normally the bond for a crime that's classified as such. So I looked that up. So now, what do we mean by pretrial release and bail? So what it means is bail is not about punishment. The only reason they consider what you're charged with when they're determining what the bond or the bail is going to be is because usually the worse or the more serious the crime you're charged with, the higher the likelihood that you may try to run and not come back to court. So essentially, they're releasing you to secure your presence. That's why. So if your bail is set at $1 million, what that means is they're going to hold that $1 million until you come back to court and finish the case. So whether you lose the case and go to jail or you win the case and walk away, they give you that money's yours if you pay your own bond or bail. Then you have what we call secure bonds. Now, I'll tell you the type of bonds. A secured bond is a bond that is essentially secured by the insurance commission and or by an insurance company, and a bail bondsman can now jump in and essentially take responsibility for that full amount. In return for taking responsibility for the full amount, the bail bondsman can charge you anywhere from 10 to 15% of the amount. So let's say if your bond is $100,000 secured, what that means is a bail bondsman can come in and take responsibility for that $100,000, but in return for getting you out of jail, they charge you 15,000, which is 15% of 100,000. So of course that's much cheaper. Now you don't get it back. There's no refund because the bail bondsman is now absorbing the responsibility of paying that $100,000 if you don't come back to court. So that's one reason. So while bail bondsmen have a responsibility to make sure you get back because they're going to be on the hook for a lot of money if you don't show up in court. So that's why it's very important, and that's why you have Dog the Bounty Hunter and people out here trying to get these people who've escaped on their bonds because if they don't get them back in a certain time, then they'll have to cough up that money. Where are we at? So that's a secured bond. Then you have an unsecured bond. Unsecured means that the bond amount is set, but you don't have to pay up front. So in other words, if it's $100,000 unsecured, which you're normally not going to get at that amount, but if it's an unsecured bond, it means you get out of jail. And what happens is if you don't show up to court, you're now on the hook for paying it. But you don't have to put any money up front or have a bondsman. Then you have what we call a written promise, or what they call on your own recognizances, where you don't have to pay anything up front. They just let you out, and it's not even a money amount hanging over your head. They're just trusting that you're going to come back. And then you have no bond, where they say there's no condition in which this person can pay any money or anything to get out. They're just going to be here because of the seriousness of their charge. And that can be what we call a hold. So they can put holds on certain types of cases. Now, pretrial detention. An individual who is not released prior to trial typically is detained in a short-term correction facility. In the case of Bell v. Wolfish, the Supreme Court held that while these detainees retain their constitutional rights, they are subject to reasonable regulations adopted to ensure order and security in the institution. The court cautioned that detainees have not been convicted of a crime and may not be subjected to arbitrary or purposeless conditions that constitute punishment. So a jail is just a pretrial detention. So you haven't, and most people in jail are awaiting trial. Now there's some people there that may be serving short time for misdemeanors, but if a person's charged with something serious and they can't afford bail, they're going to be held there until they pay the bail, and that's what we call pretrial detention. So a lot of times what happens, 95% of the time, people get held in pretrial detention. They can't afford bond. They look down the road and they say, hey, there's no way I'm going to afford to get out. My lawyers filed a bond motion and been heard on it, and it was denied. So I'm going to sit here until this case is taken care of. So because of that, even though I may not have committed the crime, because I'm kind of being held hostage and can't get out, They have the attitude that, hey, whatever deal you can make to get me up out of here, I'll take it. I'll plead guilty to anything, just get me out of this hellhole. And that's what happens. Now you have some people that kind of rely on principle and live off principle and say, hey, if I didn't do it, I'm not pleading guilty to anything. Very brave people. I don't meet a lot of clients like that. Some clients like Khalif Browder, some defendants, and of course, if you've heard of the Khalif Browder story, this is a guy who was charged and held pretrial detention in Rikers Island, New York, and he didn't. He said he didn't commit the crime, and even though the attorney that was assigned to him came to him plenty of times, say, we can make this deal, you can get out today. He was like, I didn't do it. I'm not saying I did anything. I'll wait here for my day in court to go to trial. In other words, he said, I'd rather go to trial and win or lose than admit to something I didn't do. So he rested on his laurels and his morals, and he stood there and he waited. And of course, his case kept being continued and held out and kind of prolonged. So a lot of times, even I have clients that kind of give up because the war of attrition is something they can't handle, and they just give up. Say, hey, I'll take anything. And it happens. I can't fault them for that, because guess what? I'm not in jail. So I've had conversations with clients about why they shouldn't do it, but they're like, hey, you don't got to sit in here and eat this terrible jail food. I'm cool with saying I did it. So, and these are people that either sometimes didn't do it at all, or they might have committed the act, but because of some circumstance, they may be justified in the act they committed. So they may have a defense to the crime. So in other words, yeah, I did it, but it was a self-defense. Dude was shooting at me, I shot back. But they're like, hey, if they offer me a misdemeanor or something like that, I'll take it if I can get out of jail. Get short time. So that's what happens, and can't really be mad at it. But that's how 95% of cases in the court system are taken care of by police. So you'll be surprised that there are not really that many trials in the court system. So we talked about pretrial detention and how, of course, that detention at a jail is different. There's a difference between jail and prison. Prison, of course, is usually where you're sent to do your time, especially if it's a long time. And those are punitive facilities. Now, they're not supposed to torture you or anything like that. But of course, we know what happens in certain prisons, and it can be torture, but it's not supposed to be that. As opposed to a jail, it's just short-term facility where they're holding you pretrial. Now, indigency and the right to counsel. In 1963, in Gideon v. Wainwright, the U.S. Supreme Court held that the 14th Amendment incorporated the Sixth Amendment right to counsel, and that indigent individuals charged with felonies in state courts are entitled to an appointed attorney or appointed counsel. The right to counsel in critical stages of prosecution. The U.S. Supreme Court has held that individuals are entitled to a lawyer when formal adversarial criminal proceedings are initiated against them. Following the initiation of formal criminal proceedings, the right to counsel attaches at critical stages of prosecution. A critical stage is considered to be any phase of the prosecution that may negatively impact the defendant's ability to present a defense at trial, and at which the presence of an attorney would safeguard the defendant. So those are major times, like when you might want a lawyer. That's essentially what that means. Critical stages. The meaning of all criminal prosecutions. In Egersinger v. Hamlin, the U.S. Supreme Court held that absent a knowing and intelligent waiver, no person may be imprisoned for any offense, whether classified as petty, misdemeanor, or felony, unless he was represented by counsel. In Scott v. Illinois, the justices held that unless a defendant is provided with a lawyer, a court may not sentence him or her to imprisonment. So let me see. So of course, what that means, there has to be a knowing, what we call a knowing and intelligent waiver. So what that means is a waiver of the right to counsel. So you do have a right to not have a lawyer and to represent yourself. So either way it goes, you're in court represented by someone, either yourself, an attorney you hire, or what we call retain, or an appointed attorney, an attorney you don't choose, but an attorney is given to you by the court. That could be a public defender or a private attorney like myself, who is on the court appointment list. But you can't be sentenced to jail or anything or punished in court unless it's clear that you have representation, either yourself, meaning you have to have signed a waiver and said you want to represent yourself, or through an attorney, or the appointed or retained. So of course you have to be represented by someone. So you can't just sit in court and sit still. Someone has to speak for you. Determining indigency. The Supreme Court has not defined the standards for determining whether an individual is indigent and therefore entitled to the appointment of a lawyer in a criminal prosecution. States have different standards for indigency, and in many cases, the standard is set forth in a state legislative statute. In North Carolina, they have what we call a affidavit of indigency. So the affidavit just means it's a legal document that you're sworn to. So what happens is you have to fill out this itemized document where you write your income, what you make a month, or something like that, and your assets and liabilities. So what you have to pay for, and of course that number is totaled at the bottom. And depending on what that number is of what you make, opposed to what as opposed to what you pay out, whatever the difference is, whatever that number is, if it's too low, then of course that means you're kind of financially insolvent, and that means you can't afford an attorney. So attorneys, even for petty stuff, can be expensive. Now, usually that right to legal counsel is only going to attach to serious crime. So I don't want you thinking you're entitled to an attorney for a traffic ticket. So you got a stop sign violation or ran a red light, and you got this infraction. Now you're like, I wanted a court appointed attorney. It doesn't work like that. It has to be serious cases for which you can be jailed. So determining indigency, they want to look at that amount, but they want to see that you don't make enough to afford an attorney. So of course, if you got all types of jobs and you got money, you're gonna have too much money to not afford an attorney, or you're not gonna qualify for a court appointed counsel. So the right to select appointed counsel, you don't have that right. I'll tell you up front. You're going to get the lawyer that the court gives you. So you can't. They don't give you a catalog of lawyers when you're asking for appointed counsel for you to pick. You have to take who the court gives you. Usually it's a random list, alphabetical, and they figure out who's next on the list. But where the state appoints a lawyer, a defendant has no right to be represented by a specific lawyer, although a court may take the defendant's preference into consideration, but the court doesn't have to. A non-indigent defendant possesses the Sixth Amendment right to be represented by the lawyer of his or her choice. So if you have money for a lawyer, you want to hire one, you can go out here and hire any lawyer you want, but you can't hire anybody but any lawyer. So you can't just hire Joe Schmo off the street who's not an attorney, not a licensed attorney. You have to be represented either by yourself or by a licensed attorney. So there's no option to represent your smart cousin who read a couple law books, but he's not a lawyer. That person can't represent you. You got to have either you representing yourself or an attorney. A defendant does not have the right to be represented by an individual who is not a member of the bar, meaning not a licensed attorney, or who has a conflict of interest, or whom he or she cannot afford. So of course, if you can't afford them, you kind of can't be represented by them, because we control the market and we control what we charge people. So sometimes people we're priced out, and my price is my price. You can't afford me, you can't afford me. Move on, find someone else cheaper. Um, Also, with conflicts of interest, so if let's say if I'm an attorney, you come to my office for me to represent you. I choose to represent you. Then we go to court, and I look at the alleged victim in the case, and I realize that I represent that person in another matter right now, or I've represented them before. So that means I can't represent you. It's a conflict of interest. So the other person particularly can be hurt by it, because I represented them before. That means I may have access to things that can affect them in this case, and I can use my prior representation to open up the book on them. So, of course, as an attorney, we have this attorney-client privilege. So in that situation, that would be a conflict of interest. So and there are other conflict of interest as well, but that's the main one when we have two clients where the attorney has represented one before or has access to special information about a person because of a prior attorney-client relationship. But there's no right to be represented by appointed counsel or hire an attorney who has a conflict of interest. So as attorneys, usually when we find out there's a conflict of interest, we have to get out of the case. Or sometimes we can have the conflict waive. Like if both parties agree, oh, it's cool, you can go ahead. Or the affected party, the party that would be hurt by the conflict. Uh, Maybe my client realizes that I'm cool, and the same thing is also a conflict to represent two co-defendants at the same time. Because what can happen is when you have co-defendants, one co-defendant can turn on the other and say, you know what, I'm going to turn state's evidence. I'm going to flip and snitch on the other person. In that situation, of course, I can't choose one client over the other, so I can't let one client snitch on the other client and still represent them. So that's the conflict of interest. But I've had cases where I knew it wasn't going to trial. I knew we were going to cut a deal. Both of them qualified as first offenders, so I was going to get them both out of there. Where I represented co-defendants, where they both waived the conflict. I proceeded with the conflict waiver, got the case handled without it even going to trial, so that the possibility of one of them turning on each other was non-existent. So certain conflicts can be waived, not all, but certain. The right to effective legal representation. That means effective. You have some type of effect. Doesn't mean it's going to be perfect. Doesn't mean you're going to Johnny Copper in the situation. It doesn't mean that your attorney controls the outcome. But the U.S. Supreme Court has held that there is a two-pronged test for ineffective assistance of counsel. To pass the first test, the defendant is required to identify specific aspects of the lawyer's performance that fell below the range of responsibility, um, effective competence. That fell below the range of reasonability, effective competence demanded by an attorney in a criminal case. Let me read it again. To pass the first test, the defendant is required to identify specific aspects of the lawyer's performance that fell below the range of reasonability, effective competence demanded by, and reasonably effective competence demanded by an attorney. Sorry, I read that wrong. The second question is whether there is a reasonable probability that the result would have been different in the United States. So not only you have to prove that the person did something that wasn't reasonable and fell below a standard of attorney care, what a reasonable attorney would do, but you also have to prove that it actually had an effect on the outcome. So it's two-pronged. Um, in other words, unreasonable act, something that wasn't a good idea, and whatever it was had to actually have an effect on the outcome. So if it's highly probable that the case wouldn't have been affected by it, in other words, you were probably going to take an L anyway, then it's not the counsel is not ineffective. So that means no matter what they did, they wouldn't have been able to affect or change the outcome. Um, Okay, in the United States v. Chronic, the court indicated that there are cases in which a lawyer's conduct falls dramatically below the expected standard, and that therefore prejudice will be automatically presumed. So sometimes there's some things that are so terrible that's like this attorney obviously hurt this person in the decision they made. The right to self-representation, which is the dumbest right they can hit this out there. So you have a right to represent yourself, but why would you do that, idiot? I'm just joking. Not an idiot. These people are not idiots, but they're making unsound decisions. In 1975, in Ferretta v. California, the U.S. Supreme Court held that the Sixth Amendment provides an accused with a constitutionally protected right of self-representation, um, even though it's highly unadvised that you do so. One thing about attorneys, with me specifically, I'm in court every day. I see people get screwed by the court system, and then sometimes I feel sorry for them, or I used to. But then I look beside them and say, "Hey, are you represented?" And I see this person representing themselves, and they're getting screwed. At that point, I don't care anymore because I'm like, I used to have a heart, but when you see people that aren't hiring professionals to represent themselves, um, and they're getting screwed by the court, and you're looking like, wow, if he had an attorney, the attorney would have said this, or I would have said that. And that person might not have gotten screwed. But guess what? They chose to circumvent us and go and represent themselves. So good riddance. So in the court situation, when you're in court for anything, get an attorney, even if it's small, it's a traffic ticket. If anything, the attorney at least saves you the time of having to go to court yourself if it's a non-serious traffic matter. At least you pay this attorney to now not have you sit in the court all day because it's their job to go to court. Because attorneys, we get in and out of court. We do what we do and we're out. But when you go there by yourself, you have to sit there all day. There's no preference. They're not going to take care of you. It doesn't work in alphabetical order. So if your name starts with an A, that doesn't mean they're gonna call your name on the roll first. That doesn't mean they're gonna take care of your case first. So just remember that. So always create. I mean, I always kind of give the example of if you break your leg and you're in pain, you fall, break your leg. The first thing you're going to do is say, "Hey, where's a doctor? I want a professional to look at my ailment on my leg and fix me." You're not going to say, "Oh, I'll fix it myself," because you're in pain. So you're going to get a professional. The same thing should apply to law. So if you have a legal situation, why would you ever feel like you're qualified to do it yourself? Now, as a lawyer, maybe I am, so if I'm a doctor and I break my leg, I can say, okay, hand me this and hand me that. I'm going to set my own leg. Not the greatest idea, but at least I can do it because I'm a professional. I know what I'm doing. I'm licensed, but I don't think people should be out here representing themselves. That's just my take. You have a right to it, but it doesn't mean it's a good idea. So that's the end of chapter 12. So you guys take care. Hopefully, I've covered everything for you. You kind of understand the bail process, what bail or bond, which is interchangeable for bail. We call it bond in North Carolina, but what it means. So essentially, it's not about punishment, but it's about collateral to make sure you come to court and keep coming to court until your case is done. So when you pay that money, it's all about collateral. In other words, we're going to hold this to make sure this person comes. If they don't come, we're going to take it. That's why some people to put up the house for Leon, and Leon don't come to court. Guess what? Now they lose the house. The court owns the court system and the school board. Usually that's who the court system pays all these collateral that they get to keep. They pay it to the school board, so it funds the school system, supposedly. But that's where that money goes. So now you've surrendered the house because you were dependent on Leroy to come to court. You wanted to get Leroy out of jail. You got him out, and guess what? He did come to court. So now that house you put up, that collateral is gone. So I never tell people. I say, hey, if you want to put money up for that for him, it's cool. I don't know him personally, but that's on you. But do recognize that if he doesn't show up, you're toast. The house is gone. So that's what bail is about. Bail or bond, pretrial detention of jails, everything. I kind of hope I covered everything. Effective assistance of counsel. So I think I've covered it all. Hopefully it was clear to you. I've made it more understandable. Take care. Bye-bye.